5, 4, 3, 2, 1. Start. The matter at hand arises from a dispute between the parties regarding a contractual obligation that was allegedly breached by one of them. The complainant asserts that the opposite party failed to perform duties that were explicitly mentioned in the agreement executed on a mutually agreed date. It is contended that despite several reminders and legal notices, the respondent failed to rectify the breach or provide a satisfactory explanation for the same. The matter was initially brought before the lower court, which after examining the evidence and hearing the arguments, passed a judgment unfavorable to the present appellant. The appellant, being aggrieved by the said decision, preferred an appeal before this court on various grounds. It is contended by the learned counsel for the appellant that the court below erred in appreciating the material facts and the evidence on record. Further, it is argued that the learned trial court failed to take into consideration the implications of certain documents that clearly established the liability of the respondent. The counsel further submitted that the findings recorded by the learned trial court were perverse, inasmuch as they were based on assumptions and conjectures rather than sound reasoning or legal principles. It is also argued that the impugned order suffers from legal infirmity and ought to be set aside. The respondent, on the other hand, has denied all allegations and has submitted that the appeal is devoid of merit. The learned counsel appearing on behalf of the respondent has supported the findings of the lower court and has prayed that the appeal be dismissed with costs. Upon hearing the learned counsels for both parties and perusing the record of the case, this court is of the considered opinion that certain material aspects have been overlooked by the court below. It is evident from the documents placed on record that there was, in fact, an agreement between the parties, and the obligations flowing from the same were not adhered to in their true spirit. The essence of the contract was that both parties were expected to discharge their respective responsibilities in a time-bound manner. The conduct of the respondent, as evident from the correspondence exchanged, reflects a degree of negligence and non-cooperation, which contributed to the failure of the agreed transaction. This court cannot ignore the principles of equity and good conscience while adjudicating upon the present appeal. Further, it must be noted that the parties were under a fiduciary obligation to act in good faith and not to take undue advantage of any technical lapse or procedural irregularity. The intention of the parties, as derived from the entirety of the transaction, suggests that the appellant was sincere in its efforts to comply with the terms and sought timely performance from the respondent. However, the same was not reciprocated. In the realm of civil jurisprudence, the burden of proof lies on the party asserting a fact. In this context, the appellant has discharged its burden by producing relevant documentary evidence and oral testimony. The respondent, however, has failed to rebut the same with cogent proof. The explanation offered is neither plausible nor supported by any documentary material. It is also worth noting that the learned trial court has failed to apply the well-settled principle that when a party to a contract fails to perform its obligations without just cause, the other party is entitled to seek compensation or specific performance. This legal position has been reiterated in various judicial pronouncements, and the same holds good in the facts and circumstances of the present case. Accordingly, the impugned judgment is set aside, and the appeal is allowed. The matter is remanded back to the trial court for fresh adjudication in accordance with law, after affording reasonable opportunity to both parties to present their case. The trial court is directed to dispose of the matter expeditiously, preferably within a period of 3 months from the date of receipt of this order. In another matter, the issue pertains to the grant of interim relief in a writ petition filed against an administrative order passed by a quasi-judicial authority. The petitioner contends that the order is arbitrary, devoid of reasoning, and in violation of the principles of natural justice. It is submitted that no proper opportunity of hearing was granted, nor was any speaking order passed indicating the reasons for the decision. The respondent authority has taken the stand that the action was taken in accordance with the procedural rules and that the petitioner was duly informed about the proposed action. However, a bare perusal of the records reveals that the notice issued was vague and did not specify the grounds on which the adverse action was contemplated. Furthermore, the time granted for response was wholly inadequate. This court is conscious of the fact that interim relief should be granted only in exceptional cases where irreparable loss or injury is likely to be caused and where the balance of convenience lies in favor of the petitioner. In the present case, the impugned order, if not stayed, would result in a situation where the petitioner would suffer consequences that cannot be reversed even if the main petition is ultimately allowed. Therefore, in the interest of justice, this court deems it appropriate to grant interim protection till the next date of hearing. The respondent is restrained from taking any coercive action against the petitioner pursuant to the impugned order. The matter shall be listed for final disposal on the date to be fixed by the registry. This court reiterates that authorities exercising quasi-judicial functions must act fairly, adhere to principles of reasonableness, and provide affected parties with a meaningful opportunity of being heard. Any deviation from such standards renders the administrative action vulnerable to challenge. Let a copy of this order be sent to the concerned authority for necessary compliance. The parties are directed to cooperate in the proceedings and avoid unnecessary adjournments. The registry is directed to ensure that a certified copy of this order is made available to the parties. Stop.